Hey there, YouTube fans. It's Mike Palumbo. Wanted to do a video about this Derek Chauvin trial that's going on. I've been watching it. And for those of you who don't know, Derek Chauvin's the cop that killed George Floyd in Minnesota, and he's on trial for various degrees of homicide and murder. That's really what I want to talk about. But I'm watching it not just from the human interest perspective, but from a professional perspective. Because a lot of even to this day, I've done hundreds of trials and taken testimony in hundreds of EBTs and pre-trial. I've done hundreds of pre-trial hearings, and we add arbitrations and forget about it. I don't even know how many cases I put together, how much testimony I've taken, but you can never stop learning. And I gotta say, one thing positive is that these lawyers, the prosecutors and the defense lawyer, and the prosecutors have an ensemble cast. They have some guest prosecutors coming in. They have the Attorney General of the state of Minnesota has done direct examination of some witnesses. The Assistant Attorney General of the state of Minnesota, former Solicitor Generals of New York State have come in to help the prosecution, and the main prosecutor. I mean, these guys are just spot on professional, know exactly what they're doing, and the defense lawyer is tremendous as well. Don't hate the defense lawyer if you hate his client, which is pretty easy to hate his client, because everyone needs a lawyer. Everyone needs, especially Chauvin, needs zealous and competent counsel, and the lawyer that's representing him specializes in representing police officers, and he's just tremendous too. The judge is really running the trial really well. He's not egotistic. He's not preempting anything. He's very professional. So from that perspective, I'm learning a lot. I'm refreshing my skills as to direct and cross examination. So that's the two reasons. And I'll be honest with you, it's a really hard trial to watch. I do think Chauvin's guilty. I just don't know how you get around not just the videotape, because sometimes videotapes can be inflammatory and not tell the full story. But I think in this case, there's so many videotapes out there from police body cams and civilians. I really don't think there's anything being left out. And just how you can let a man just I'm not even saying I'm limiting it to this, but just at the end of the day, how once someone becomes non-responsive, you cannot help that person who's in your custody is beyond me. Just beyond me. So that's why that's a main reason. That's something I can't get over. Okay, I mean, I'm not saying that everything else he did that led up to the Floyd becoming unconscious wasn't a crime in and of itself, but that's just the thing I can't get over. You don't need to be trained. It's common sense. Someone's in your custody or something, or even just in a fight with somebody and they go unconscious, at that point, you continue on. It's definitely, some sort of crime, But there was a lot of controversy earlier in the year about what he was charged with, and that's really something. That's what I really want to talk about. Now, you got to start with the understanding that all murders are homicides, but not all homicides are murders. So you can have a homicide and it cannot even be a crime because it was justified. We give medals to kids on battlefields who kill the enemy. So in and of itself, a homicide is not necessarily a crime. An unjustified taking of a life is a crime, and then it could be a murder or a manslaughter, or now the varying ways, murder, manslaughter, negligent homicide, these are creatures of state statute. So in other words, what could be a murder in New York State it could be a manslaughter somewhere else. Now it doesn't mean it doesn't reflect. Now a murder is the worst thing you could do because there's some quantum of intent or just callous disregard to human life, versus a manslaughter would be an accidental taking of a life. But so the elements of one state may not be the elements of another, and the actions have to fit the elements of the crime to be found guilty of it. And while I was doing a little research for this in Minnesota law, like I found that Minnesota law really doesn't like drive-by shootings because those are aggravated crimes. So you shoot someone in a normal situation, it's not as bad as if he did a drive-by shooting. They also don't like homicides, murder, taking of a life, even accidental, if you're committing a sex crime. So I don't think that particular nuance, which would upgrade it, certainly anywhere, you're committing a sex crime against someone, you kill them, it's certainly a crime, but it's a much higher crime in Minnesota than it is in other states. It's also, they seem to have more more understanding if you flip your lid over something that someone would flip their lid about, and then, anyone else probably wouldn't have killed the guy, but you then all of a sudden snap and you kill somebody. It's still a crime, but it's not that big of a deal. You can get away with 10 years or 15 years in Minnesota, where you'd be doing life somewhere else. So the point is, all these varying degrees of criminal homicide are creatures of state statute. And what happened in Minnesota was, there was a lot of hue and cry as to why Chauvin wasn't charged with the worst possible murder charge, which in Minnesota is murder in the first degree. And he's not facing those charges right now. But there was a lot of stuff in the media. And so what do you got to prove to show murder in the first degree? And again, then murder in first degree carries life. It doesn't get any worse in Minnesota. And you get either cause of death. The statute requires that you cause the death of a human being with premeditation and with intent to effectuate the death of the death of the person or another. Okay. Yeah. Affect the death of a person or of another. I don't know what that means, a person or of another. I guess if you try to kill one person, but you accidentally kill somebody else, but you're intending to kill that person, I think that's what that must mean. So, I'm watching the trial, premeditation and intent. And let's just talk about those two things, okay? I mean, certainly if someone's a contract killer, it's pretty easy to prove premeditation. Or you went out and you stalked somebody and you've been calling this person, and or you could be a stalker that kills somebody, and this day you bought a gun or a knife, and you broke into the place, and it's kind of easy to prove premeditation in those cases. And then you got with intent, right? Now intent can be proven, in two ways, and the primary way of proving intent is implication through actions. So, unless the guy gets on a stand or somehow is recorded by saying, I took that effort down, whatever, I'm glad I did it, it's about time, whatever. Unless you have some sort of recording that the guy intended on doing it, intent is normally proven through actions. And, I got to tell you, and premeditation and reading all these statutes together, in New York State, under New York State law, statutory, not really statutory, but it's interpretive law, when cases go on appeal and courts of appeals make rulings. In New York State, premeditation can be formed in the blink of an eye. But in reading all these statutes together, premeditation really, I haven't really read any case law on it, but it seems to me it takes a little more in Minnesota to prove premeditation. And that's probably why he wasn't charged with murder in the first degree. Because I watched a substantial amount of the trial, definitely not all of it, but I'm saying like, at a certain point in time when Floyd passed out and was clearly not even moving, and he just kept up the crushing injuries that he was causing, I think you can prove intent to kill, to effectuate the death through his actions. I can see the prosecutor not really wanting to charge this charge. It might be very hard to prove, and then you end up watering down your case. You end up looking like a bully, and you can get sympathy for the guy. So I can understand that. What also is striking to me is that there's no recklessness requirement. In other words, there are various ways of committing all these particular homicide crimes in Minnesota. I'm only pulling out the ones that are relevant here. And there's two things you need to find someone guilty of any crime. You need an act or an omission where you should have acted. So you need an act or an omission where you were obligated to act. And you need a culpable mind, called mens rea. And there's four mens reas. You got intent, knowingly, recklessly, and negligently. And recklessly, really, to me, is really the cousin to intent, because recklessly requires that you perceive and consciously disregard a known danger. The murder in the first degree in Minnesota doesn't have. There's no way of committing murder in the first degree in Minnesota recklessly. So even though, like, I can understand why people were complaining that he wasn't charged with murder in the first degree, I could definitely understand why he wasn't charged, because there's no recklessness standard here in Minnesota. And probably if I was the prosecutor, I would have let that alone too, because again, you don't want to have to try to prove something that's so hard to prove when the other three charges are much easier to prove. He's charged with murder in the second degree, murder in the third degree, and manslaughter. Murder in the second degree is the top charge that he's facing, which carries 40 years in prison, and based on his age, it's probably going to be a life sentence anyhow, if he's found guilty of murder in the second degree. And second degree, third degree, and manslaughter. So the murder in the third degree and manslaughter are lesser and included. So a jury can reject murder in the second degree, go for murder in the third degree, or they can reject both of those and go for manslaughter. So now what happened pre-trial was that the prosecutor charged murder second, murder third, and manslaughter in the second degree. And the defense made a motion to dismiss the murder in the second degree before the trial judge, and it was granted, which is masterful work on the part of the defense lawyer, because usually, charging what to charge someone with really is really within the purview of the prosecutor. But what the defense argued was, hey, the elements don't fit. My client's worst day doesn't fit the elements of murder in the second degree. Well, the prosecutor appealed that decision, and the appellate court said, no. It was the prosecutor was in his right to charge it. So then that charge was reinstated, murder in the second degree. So how they got to prove that? Okay. Again, there's a lot of ways of committing murder in the second degree, but the way it would apply to Chauvin would be cause the death of a human being with intent to affect the death of that person or another, but without premeditation. So, that's why, when you look at this case, I'm sure the prosecutor said it's really going to be hard under our laws, under the elements that we have to prove premeditation. So we're not even going to waste our time with it. And another way of doing it, of committing it, would be cause the death of a human being without intent to affect the death of any person while committing or attempting to commit a felony offense. Now, from what I understand, these are two subdivisions. He's not charged with subdivision 1, causing death of a human being with intent to affect the death of that person without premeditation. Now, again, intent is always, most of the time, implied through your actions. And usually it's a knew or should have known. You knew that by continuing to use this crushing injury force on him, and he passed out, you knew that could lead to his death, or that was going to cause his death, or you should have known. That's at least a standard of, know or should have known. A reasonable person would have known that. He's only charged with subdivision 2, intending to, not intending to kill him, while committing another felony offense against the person. I think they both fit. I actually think subdivision 1 fits better than subdivision 2, what he's actually facing, and here's why. Because they got to prove under subdivision 2 that he was attempting to commit another felony offense against him, but he's not charged with another felony offense. But the theory of their case is, and I think it's a proper theory, and I don't understand why they didn't charge him with it, just to clean up this subdivision, felony assault. Now, probably didn't charge him with it because they don't want to give the jury and out just to find him guilty of felony assault. That's probably why they did it. And again, I'm not privy to, I haven't really, would have took me a ton of time to do a lot of legal research. Because what ends up happening is courts will end up, so how do you got to, it's a statutory construction, statutory interpretation. How do you got to interpret a statute? Well, you want to know what the intent behind the statute is. And ways of doing that is you get the legislative minutes. When the legislature was debating what these statutes were to mean and why they were putting them in place, you could derive their intent that way, and that's one way. But what ends up happening is, I'm sure there's been a guy in Minnesota over the years, excuse me, that was found guilty of murder in the first degree, and he went up on appeal, and his whole appeal wasn't that he didn't do it. His whole appeal was he did it, but really it was what he did. The elements of what he did doesn't fit the elements of first degree. It fits the elements of second or third degree, and he made that argument to an appellate court. And again, the difference between first degree murder and second degree murder in Minnesota is life versus 40 years. The difference between second degree murder and third degree murder is 40 years versus 25 years. So if you can get first degree murder down to a third degree murder, it's a good day for you. And these courts make decisions, and they interpret the law, and they interpret the statutes, and they also seek back to what was common law, commonly known under common law of these terms. Both sides try to prove what intent is, and the court makes a decision. And when a high enough court makes a decision, it becomes law of the land. That's what the interpretation is. That becomes the way that the statutes have to be interpreted. So I can't really be too critical of a prosecutor for really not doing it the way I think it should have been done, because I'm only reading the plain words of the statute, and that's never really enough. I'm seeing subdivision 1 of murder in the second degree requires causing a death with intent to effectuate the death. And when you just lay on someone, keep your body weight against them to the point where they pass out, it took them 7 minutes to pass out, you do it for another 2.5, 3 minutes, and that person's not moving, you use that force against them. And again, you could also view it in the eyes of a professional standard. A police officer is a professional, understands use of force, escalation, and de-escalation. And as a matter of fact, yesterday the defense witness called their own expert, a prior police officer, a guy who does use of force instruction, to basically say it wasn't really a use of force, to kind of, and the prosecutor ate the guy for lunch, and very politely and just walked him through, what he testified on direct, what no police officer is going to deny is the use of force continuum, and he just ate him for lunch. But again, the intent, know or should have known. That's the way I'm reading it. You knew that continuing to do this, you didn't really mean to kill him, but you knew that continuing to sit on him for all that period of time and impact his ability to breathe would have killed him. And you knew that when he stopped resisting, you should have let up your force. Well, I didn't exactly know it. Well, you should have known it, right? You knew or you should have known. So you did intend on doing it. But again, in Minnesota, the statutes may not be interpreted like the way I find them to be commonly interpreted in New York State. So that could be a big reason why, they only went with subdivision 2, and it's an unindicted charge. I think it'll pass muster. I think it'll pass muster. Now, murder in the third degree carries 25 years versus 40 years without intent to affect the death of another person, causes the death of another person by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life. I mean, this one's spot on, okay? I don't know how you get around this one. Murder in the third degree. I mean, this one is a shining light, Again, I actually think it should be murder in the second degree, based on my watching but I could see a jury breezing over that one and going for murder in the third degree. And then there's manslaughter in the second degree. He's also charged with manslaughter in the second degree, which carries up to 10 years in prison. He caused the death of another by any of the following means, is guilty of manslaughter second degree. Oh, on the second page, I got the means, the way you could do it. culpable negligence, where the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. And based on the witnesses that I've seen so far that the defense has produced, and based on the cross-examination of the defense, I could tell that his lawyer, that Chauvin's lawyer, has told him, "Listen, we're shooting for manslaughter, so you can get out in 10 years. That's going to be a home run. That's our. Don't even think you're walking out that door a free man. You're not. The question is, are you going to get 40 years, 25 years, or 10 years? The question isn't whether or not you're going to lose this case and go to jail. The question is for how long. And if this thing comes out to a manslaughter in the second degree, if he gets found only guilty of that, first of all, his lawyer is doing an excellent job, and his lawyer is facing a battery of heavy hitter lawyers on the prosecutor's side. So he doesn't have favorable facts. But if he gets a manslaughter in the second degree, this guy should be like lawyer of the year, because it's minimally a murder in the third degree. And again, I haven't watched the entire trial, but I watched a substantial portion of it, and I think they made a case for murder in the second degree for the 40 years. It's a very hard case. It's a very hard, really. It's very hard for me to watch the trial. I don't really want to get too into it, but anyhow, from an analytical standpoint, that's what's going on. And whether you're Derek Chauvin and a very loathsome creature for what he did, or just some other guy out there, for justice, you really got to put aside your personal feelings, and the penalty and the conviction has to fit the elements, whether you like it or not. So he's entitled to the defense he's getting, and I just really feel bad for George Floyd and his family. I could do a whole other video as to I don't even know why they took him out of the car. Honestly, I hate to rant, but they had him in the car. Okay, I know he was freaking out and stuff, but they had him in a secure location in handcuffs. Why do you got to pull him back out? I understand maybe he could hurt himself in there, maybe he could bang his head against a window or something, and you're responsible for that. Okay, but he wasn't doing that yet. It was like he went in one door and then. There's a lot of body cams out there that a lot of people haven't seen. I watched the trial, and it was like in one door, like a clown car, and out the other door. Like, what was the purpose of even just doing that? Let him sit in there, let him freak out in there. Call your ambulance. If he starts to hurt himself in there, then go in and try to restrain him further. Maybe just try to put him in a seatbelt or something like that. It was in half. I'm going off. I'm sorry. Anyhow, it's Mike Palumbo. I hope you got something out of this video, and I hope you have a tremendous day.